Hi guys, welcome back to my channel. Welcome if you're new. My name is Kseniya and I make videos for people who, like myself, are going through the family-based immigration process. I'm not an immigration attorney. My videos are based on publicly available information, my own experience, and the experience of my subscribers. The purpose of my channel is to give you guys the confidence to go through this process completely on your own. Being separated from your family, from your spouse and your children is a very, very difficult thing, and immigration cases take a very long time. However, rushing your case can be very detrimental, and it may not only cost you a lot of money, but at the end of the day, it can delay your case even longer. So in today's video, I wanted to give you guys 5 reasons why you should wait to apply for your family-based green card. And these are based on very, very common, very frequent mistakes that I personally see when people come to me for help or they come to me to ask questions. So the first reason why you need to wait is actually a very straightforward reason. You probably would have guessed it already, and that is by rushing your case, you may make a lot of very little mistakes that don't seem significant in the moment, but they do cost you a lot at the end of the day. You can be making little mistakes like misspellings, misspelling names and addresses, but also miscalculating things such as miscalculating the household size on the affidavit of support form. The other mistake that I frequently see people make is rushing to submit the applications and not really caring about the evidence that much, thinking that they can send in the applications first and worry about the evidence later. But what's going to happen is if you don't send all the necessary evidence with your file in the very beginning, USCIS will send you a request for evidence. However, what you need to realize is if you receive a request for evidence, that means that your file will now be going to the end of the line. So whoever is reviewing your case, they have piles of cases to go through, and if they notice that your case is missing certain evidence, your file will now be put on the back burner while they're working through the rest of the cases. And even if you try to send in this evidence as soon as possible, it still means that your case is now at the end of the line and they will not continue working on it until they receive everything they need. You really want to weigh in. Do you want to wait a couple of extra months to collect this evidence to make sure everything is ready, or do you want to delay your case by 6 months or more? Now I want to go over the second reason why you should probably wait to submit your immigration file, and that is not waiting until you meet appropriate income requirements. I see this a lot with petitioners and sponsors who really can't wait to get started on their immigration journey, but they're not meeting the income requirements based on their most recent year's tax returns. I have a lot of different videos talking about the affidavit of support. I would say that about 90% of the time when people message me with questions or concerns, it is in regards to the affidavit of support and the income requirements. Unfortunately, a lot of the times they come to me when they have already received a request for evidence from USCIS. And one of the most common reasons why people receive this request for evidence is because their previous year's tax returns don't show that they meet the income requirements. USCIS does ask you to provide what is your current income, and then on the affidavit of support, they ask you to provide what is your tax income from previous years. In the form instructions, they do tell you that there are different types of income that you can use to sponsor somebody. However, in reality, what I'm going to tell you right now is that they only care about your tax returns, your most recent year's tax returns. And that is the easiest and fastest way to get your case approved if you have an appropriate amount reflected on your most recent year's tax returns. Even better if you have an appropriate amount of money reflected on your most recent 3 years tax returns. I see this a lot in the cases when people say, well, I didn't work last year, but I actually just got a job and my job is paying me a lot of money and I'm definitely meeting the income requirements based on my current income. I also have people come to me and say, well, I'm getting a new job. I'm starting next month. Can I just submit my documents and show them my employment letter, my offer letter? And in reality, they're not going to care about that. They don't care if you're starting a job in the future. They want to see that this amount of money is something that you're making right now and that you have made it in the past tax year. I know it doesn't make any sense because maybe your last year's tax returns show that amount, but you actually now are unemployed. I know that it doesn't make sense. However, that is all they care about. If you really want your case to be quick and easy, you want to make sure that that amount of money is reflected on your tax returns. You definitely have options in this case. You can either use your assets to supplement whatever the difference is. You will obviously need to show evidence for that, such as 6 to 12 months of bank statements. Your other option is to obtain a joint sponsor. In some cases, it may be more appropriate to just wait a few months. So if, say, for example, you are trying to sponsor your spouse or your parents, you are trying to get this case started in December or towards the end of this year, but it didn't show that you were making enough income on last year's tax returns, and in that case, maybe it would be worth to wait a couple of months until you're able to file the updated tax returns for the most recent year to have that amount reflected on them. And then those tax returns will definitely help you sponsor your relative and make their case a little bit faster. I understand that you want to get your family member here as soon as possible, or you want to get them to stay. Just like with our previous point, you will have to really weigh in your options. You either want to wait a couple of months, like 2 to 3 months, 4 months, until you file your new taxes and have that amount and then have all that evidence ready to sponsor your family member, or you can risk it by sending the old tax returns with insufficient amounts and then hope that they will not send you a request for evidence, which I guarantee you they will. And then that request for evidence will delay the case by a few more months. And then what's going to happen when you get that request for evidence? What if you, by the time you get the request for evidence, you have not yet filed the updated tax returns, and now on top of that you have a very strict deadline to submit all of that evidence? You can jeopardize your case by risking it as opposed to waiting until you're fully prepared. If you are worried that your relative's visa or status is going to expire, I want to just remind you that for immediate relatives of US citizens, visa overstay will be forgiven. So you really have nothing to worry about in that regard. In addition, you can get started on things like the initial I-130 petition and just wait to submit the rest of the evidence, the rest of the applications. An approved I-130 petition doesn't really expire unless you are completely inactive with immigration for 2 years. Then they will close down your case. But you can get ahead and get started on the I-130 petition, get all of that in order, and maybe by then, after a few months, you'll be able to have updated tax returns, or you'll be able to get a joint sponsor. With an approved I-130, if you're doing consular process, once the NVC sends you a welcome letter and they ask you to pay the affidavit of support fee, to submit the affidavit of support, there isn't really a strict deadline. You will have probably between 1 to 2 years to get it all situated and submit all of that evidence. Obviously, I understand that you may not want to wait a whole year to bring your relative here. But if it's a matter of a couple of months, then maybe it's worth to wait a couple of months, file the updated tax returns, and then submit it all with sufficient evidence. Now that brings me to my third point, why it's worth waiting, and that has to do with obtaining the evidence of bona fide relationships. This applies heavily to people who are doing the marriage-based green card applications. There really is not a specific time you have to wait after you get married to get started on your case. If you have all the evidence, as soon as you get a copy of a marriage certificate, if you have plenty of evidence, you can go ahead and get started. But for a lot of people who maybe are new to their relationship, they haven't been together for a long time, in some cases it may be more appropriate to wait a little bit to collect more evidence of your bona fide marriage. In the marriage-based immigration cases, they are a lot more strict with the evidence that you're submitting. They're going to review it in even more detail as opposed to other types of family-based petitions. That brings me to my fourth point actually, and that one is also for marriage-based applicants, and that is there are times where you should wait a little bit longer as opposed to rushing your case, and they can make a real difference for your immigrating spouse. The difference for them lies in receiving a 2-year conditional green card or a 10-year permanent green card. If at the time of your spouse being approved for a green card, you have been married for less than 2 years, your immigrating spouse is more likely to just receive a conditional 2-year green card. And that means that there will be additional paperwork involved. Eventually, they will have to apply for removal of these conditions, meaning that they will have to submit an additional form, additional evidence of your marriage. You want to kind of estimate how long it might take for your case to be processed. In most cases, when it comes to marriage-based cases, marriages to U.S. citizens, the case processing timeline is about 1 year. By the time you may approximately have your interview and get approved, will you be married for less than 2 years or more than 2 years? And it could really make a huge difference for your immigrating spouse. Maybe you can afford to delay your case by a couple of more months by waiting to submit the adjustment of status application, or again, the consular application, to make sure that your spouse gets their 10-year green card right away. They wouldn't have to go through the pain of submitting yet another application, paying an additional fee, collecting additional evidence. So I definitely suggest that you weigh your options in this regard too. And my fifth and final point, and that is, I understand that not everybody can afford to wait. If your family member is currently inside the US, you may be worried about their current status expiring, whatever visa they came on. You may be worried about trying to submit their case as soon as possible because their status will be expiring very soon. You want to make sure that you file this application while they're still in status. I just want to remind you that for immediate relatives of US citizens, visa overstay or being out of status is forgiven. Granted that they entered the US legally, meaning that they had a visa, they entered the US, but now they overstayed. So in the case that you need to take the additional time to collect this evidence, you definitely can if you are petitioning your immediate relative and if you are a US citizen. In some cases, it even builds a stronger case if you wait longer and wait until you are out of status, so that you demonstrate that your circumstances really changed, that you didn't plan, your intent was not to stay in the United States, but essentially you had to remain, and this is the reason why you're adjusting. Especially if you have been in the US for less than 90 days. I have a video talking about the 90-day rule and why it matters. Doing anything such as getting married or adjusting your status in less than 90 days, or if you are on ESTA in less than 60 days, then it can look suspicious to immigration. So perhaps it might be even better for you to wait longer. Again, I'm not an attorney. Don't take this as a legal advice, but this is at least what I see people experience. So I hope that you found this video useful. Give this video a thumbs up so more people can see it, so we can help more people. Subscribe to this channel if you haven't already, and I hope to see you in my next videos. Bye.